Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. Hopefully everybody's doing well. So as of right now, there are only two states in this country that require background checks for ammunition. The first, of course, was California, and like it always does, it spread to the second, which is New York, and who knows how many others will follow if these laws are allowed to stand. Now, don't be fooled into thinking that these laws were created because the states crave safety. This has nothing to do with safety and everything to do with controlling all aspects of your right to keep and bear arms. Imagine if you needed a background check or had to pay a small fee to the government every time you wanted to attend church or even just to speak freely, or you couldn't write a book or an online blog until you ran your name through some state database first. People would be outraged and it wouldn't be allowed to stand for a second. But make those same requirements for practicing the Second Amendment, and the courts not only turn a blind eye, but actively work to uphold them and side with the state because of their own personal agenda. Well, unfortunately, we have another case of that happening that we need to talk about today, where the court just upheld background checks for ammunition, and you're not going to believe why. So let's get into it. Now, if you believe that background checks for ammunition violates our Second Amendment rights, smash that thumbs up button and consider subscribing. It's free, it only takes a second, but it really does help us out here quite a bit, and I really do appreciate it. So let's go ahead and talk about what's going on here. So like I said in the beginning, as of right now, only California and New York require background checks for ammunition, which is an activity that is directly tied to your right to keep and bear arms. Both states have active lawsuits against those laws, and both are currently at their respective courts of appeal. It's the Ninth Circuit for California in a case called Rody v. Bonta, and it's the Second Circuit for New York in a case called New York State Firearms Association v. James. Those are two courts that have an absolute disdain for our Second Amendment rights. Two courts that sadly have more activist judges than judges who believe in the Constitution. Well, with that being said, unfortunately, less than a week ago, a three-judge panel of the Second Circuit decided to uphold New York's law requiring people to pay a fee and wait for a background check to be completed before obtaining ammunition. That's if you got it at all, because false positives and wrongful denials are actually a thing, saying that the law and the activity that it regulates doesn't even implicate the plain text of the Second Amendment. Now, let that sink in. They said that they don't have to go to the history phase of the Bruin framework because the argument fails at step one, which is text, which is in stark contrast to a July 3-judge panel decision from the Ninth Circuit, where the court said this while overturning a similar law in California. So check this out. This is from the Ninth Circuit, arguably the worst court in the entire country on the Second Amendment. This is from July 24th of this year in a case called Rody v. Bonta, challenging pretty much the same thing, where the court writes, affirming the district court's grant of a permanent injunction, the panel held that California's ammunition background check regime, which requires firearm owners to complete background checks before each ammunition purchase, facially violates the Second Amendment. The panel applied the two-step framework set forth in NYS RPA v. Bruin. Now that's kind of shocking that that came from the Ninth Circuit, right? Well, that's now on appeal to an en banc panel, and the three-judge panel's decision has been stayed until the Ninth Circuit is done with it. But the point that I'm trying to make here is that even the Ninth Circuit, which is a joke, can see that these laws are unconstitutional, but not the Second Circuit. The Second Circuit activist judges said this instead. Now, the Second Circuit writes here, on the merits, plaintiffs argued that the district court erred in concluding that they had not shown a likelihood that the challenged law is unsupported by a well-established historical tradition of firearms regulation, which is a requirement for success on the merits of their constitutional challenge. However, we do not need to address the district court's historical analysis because we affirm on a different basis, namely that plaintiffs have failed to demonstrate on the record that the modest conditions the ammunition background check provisions impose on the commercial sale of ammunition meaningfully constrain their right to keep and bear arms. Thus, we conclude, albeit on a different legal ground, that the district court correctly denied the preliminary injunction because plaintiffs failed to demonstrate a likelihood of success on the merits. So unlike the Ninth Circuit, the Second Circuit says that they don't even need to look at history and tradition because the law doesn't, quote, meaningfully constrain the right to keep and bear arms. Well, who the hell decides what's meaningful? I mean, I'm sure if you ask anybody that's watching this video right now, or anybody who lives in California or New York that values their rights, if they think it's meaningful, I bet they'd say yes. But to a left-leaning judge from the Second Circuit, I guess not. Saying something isn't meaningful and therefore isn't an infringement leaves the door fully open to be interpreted by the person who is considering the law's constitutionality. It's absurd to think that that's the standard that they applied here, but it is. If every court in America used that excuse to uphold a law, there would be literally nothing that they couldn't get away with. Now, that was an appeal to the Second Circuit from a denial of an injunction, not a final order from the district court, which means it goes back to the district court once again. However, the district court was just as bad when they denied the injunction in this case. So don't get your hopes up that they'll be overturning anything. I think we'll probably see this go back to the Second Circuit for another terrible review. And hopefully we get a good decision from the Ninth Circuit's en banc panel, which would eventually give us a circuit split that we need to take, this case at least, to the Supreme Court. So for now, background checks in New York are upheld and being enforced. And hopefully that changes soon. But until we get judges that believe in all of our constitutional rights, it's just going to keep going down like this. The Second Circuit has proven once again that they do not value the rule of law. They're a joke, just like the Ninth. Anyway, I wanted to let you all know what's going on here. I want to thank you all very much for watching. I really do appreciate it. If you haven't subscribed yet, consider hitting that subscribe button. It helps us spread our message and lets the platform know that people want to see content like this. And if you're somebody who is already subscribed, make sure you double check to see that you're still subscribed. Thank you all very much for watching. I hope you all have a great day.